Introduction of Malay Reserve Land. Malay Reserve Land or Tanah Reserve Melayu in Malaysia is a unique kind of land that is only available to Malay Muslim. This implies to non-Malay Muslim and indigenous people from Sabah and Sarawak are not permitted to buy or possess this kind of land. A bumi lot is a piece of land or property that can only be acquired and owned by Bumi Putras, which comprise non-Malay Muslim, Malays, indigenous people or asli of Peninsular Malaysia and resident of Sabah and Sarawak. State authorities are in charge of all land affairs. Therefore, each state may have a different Bumi quota. Malay Muslim in Malaysia is called Malay Reserve Land. Has no end date. It is eternal. Bumi lot which is accessible to all Bumi Putras, including indigenous peoples and Malay non-Muslim, and it can be either freehold or leasehold. Malay Reserve Land cannot be sold or transferred to non-Malay Muslim.
Then, I will explain the objective of the introduction of the Malay Reserve Land enactment. As for the introduction of the torrent system, many Malay has come to lose their right to their land because the torrent system stated that everything must be registered and registered land came with an ownership. Long story short, MRL is introduced to protect Malay right to their land. During the old day, due to poverty, the Malay tend to sell or lease their land to non-Malay or even foreign immigrant. As a result, this has caused Malay to lose their power on their own land. Meanwhile, the British is trying to prevent Malay Reserve Land from being disposed by any means to the non-Malay. And the introduction of the Malay Reserve Land has caused many dissatisfaction from the Malay since it has caused them the difficulty to dispose, transfer, sell or lease their land to the non-Malay. Then, the introduction of the MRL is to prevent private dealings between Malay and non-Malay in terms of Malay holdings, or MRL. Even with the establishment of the regulation, many Malays still choose to openly or secretly sell their land to the non-Malay. There are few land that can be declared as Malay reserve. These include state land, reserve forest land, land reserved for public purposes, and alienated land. As for the condition for MRL, it is agreed upon the Malay ruler where under the Malay Reservation Enactment 1913 covering the Federated Malay State of Selangor, Perak, Negeri Sembilan and Pahang, and all land declared as Malay Reserve Land cannot be at any time be sold, leased or handed over to any person who is not Malay, unless it is declared and enacted to be void by the Menteri Besar. Now, we will move to the case review. For our first case, we will be reviewing the case of Bibi Sakimah binti Muhammad Arif versus Pendaftar Hak Milik Negeri Perak that occurred in 2021, and this case is located under the subtopic Malay holding. To simplify, the plaintiff is a non-Malay who successfully bid on a land which is said to be a Malay reserve land by the defendant. However, even after the plaintiff came to the defendant with the Form 16F, which was prosecuted by the Senior Assistant Registrar of the High Court in Perak, the defendant still be rejecting the plaintiff application to be the proprietor of the subjected land with the reason of the plaintiff is not a Malay. As a result, the plaintiffs bring this matter to the court, and the court held that the defendant was ordered to register and issue the plaintiff an issue document of title in the plaintiff's name after listening to the plaintiff citation. Provision of Section 293 Clause 1 of the National Land Code stated that every instrument presented has to be accompanied by the prescribed registration fee, and pursuant to Section 293 Clause 3 Clause A of the National Land Code, the registrar ought not to be penalized the plaintiff, and the penalty of Ringgit Malaysia 750 ringgit was ordered to be refunded to the plaintiff. It is portrayed in Section 8 of MRE that it is prohibited that Malay holding to from being transferred, charged or leased otherwise disposed to any person who is not Malay, and prohibit any memorandum of transfer, charge or lease from being registered in the contravention of that any section of any land office or land registrar. And in this case, the plaintiff has clearly stated that she is not a Malay, and the court has stated that the particular land is not under Malay reservation land. So the plaintiff has the right to be the proprietor of the land.
Case 2, Mok Yong Kong and Anna Mok Yong Chuan, 2002, NLT 718. The fact of this case, the respondent was the registered proprietor of a 1/3 undivided share in 3 pieces of land until 1975, which were later transferred to his brother, which is first appellant, based on an agreement. The agreement stipulates the transfer of the 1/3 share to the respondent after using the land to raise funds. The second appellant and the respondent lodged a caveat on 2 June 1997. The High Court dismissed the appellant's application to remove the caveat, leading to his appeal that argued the caveat against the registered proprietor is groundless, since no credible claim to the title or interest was made against them. The appellants contend the caveat should be removed, aligned with the grounds stated in the application following 323 bracket 1 of National Land Code 1965. Court decision of this case, the decision to remove a caveat rests with the judge. It does not interfere unless there is a clear case of injustice. This appeal is considered exceptional and falls within circumstances where the appellate court may intervene. The appellate's counsel assert that the grounds stated in Form 19 are sufficient for the appeal. The statutory declaration dated 31 May 1997 outlines the allegation made by the respondent, including claims of fraud against both appellants. The second suit seeks the retransfer of the 1/3 share but does not make any allegation of impropriety against the second appellant.
Next, for the case 3, Jamaluddin bin Jaafar versus Affin Bank, Berhad and another appeal, 2016, Court of Appeal. So the facts from the case is the appellant charged his Malay reserve land to Affin Bank that obtained a default judgment and pursue bankruptcy proceedings. It is arguing that the third party charge in favour of the bank was null and void. So the appellant claimed that the respondent bank was not a Malay under the Kedah Malay Reservations Enactment. The appellant also appeals to the Court of Appeal that the dismissal of the applications asserting the invalidity of the charge due to the respondent's non-Malay status. The issue from this case is that the Kedah enactment allowed a Malay reserve land to be charged to the respondent bank, which is a non-Malay. So the Court of Appeal allowed the appeal to the respondent that being a non-Malay, note this in the second schedule, is prohibited by Section 6 of the Kedah enactment from holding any right or interest in the Malay reserve land. It is irrelevant to its qualification as a Malay under the Kedah Enactment. So to conclude from this case, that the third party charge in favour of the respondent is null and void to its non-Malay status.
Case 4. Tan Sri Datuk Lim Cheng Pao versus Bella Jadi Sendirian Berhad and another appeal 2021. Facts. Bella Jadi initiated a case against CME and the guarantor to collect rental payments. Bella Jadi sought RM8,401,756.85 in damages for past due rent and interest at the time the lawsuit was filed, as well as rent for the duration of the 3-year tenure. CMA disputed the tenancy agreement's legitimacy in its defense and counterclaim. It claimed that the lands on which the premises were erected were subject to an express stipulation that they be utilized solely for residential purpose. Court decisions. On 20 May 2015, after a thorough trial, the Len JC rejected Bella Jadi's suit against CME and the guarantor and granted CME's counterclaim. The Len JC determined that the tenancy arrangement was invalid and void from the start since it violated the stated condition of ownership to the properties. Based on the same reasoning, the Len JC determined that the guarantee of the tenancy agreement was similarly null and invalid. The Court of Appeals concluded that the fact that the process of conversion had been commenced did not change the fact that the express condition of title prohibited the use of the building for the purpose specified in Section H for Schedule 1 of the Tenancy Agreement.
Lembaga Pembangunan Insan Negeri Johor was Zainul binti Muhammad Saad and Anwar. Fact, landowner Zainul binti Muhammad Saad and sister battled with the Johor Iskandar Regional Development Authority in 2012. The accusation include LPI ignoring legal process and insufficient consultation with infect landowners. Emphasis on the importance of fair compensation and relocation assistance for infect landowners, particularly Malaysian, about stirred debate on the complex relationship between development, affirmative action, the public good and individual right in Malaysia. Zainul and sister eventually accept compensation and move out, but the case had a lasting impact on Malaysia legal landscape. Federal Court delivered a announced verdict case of Lembaga Pembangunan Insan Negeri Johor was Zainul binti Muhammad Saad and Anwar to recognize tension between public development and Malay land right. Potential public benefit for prioritized safeguard Malay land ownership with strict condition and acquisition. Mandate fair compensation and appropriate regulation assistance for displaced landowner. The protection of Malay land right influence future legal ruling and spark discussion about the delicate relationship between affirmative action and public project in Malaysia. General rule: Malay Federal Court established a crucial general rule for compulsory acquisition of Malay reserve land for public development. Rule prioritization, balancing public interest with protecting Malay land rights. Authority can acquire MRL under the Land Acquisition Act but must fulfill specific conditions. Decision recognizes the crucial role of MRL in protecting Malay land ownership, ensuring consideration of both public interests the Malay land right in decision regarding MRL. Conclusion and discussion. In summary, the Malay Reserve Land Policy in Malaysia designed to secure the land ownership for Malays has achieved its goal of economic empowerment and culture preservation but poses challenges. 1. Fostering wealth generation and cultural identity is also sparked debate on market efficiency, racial integration and constitutional equality. Criticism argue that it is limit property accessibility for non-Malay, potentially hindering market flexibility and contributing to segregation, balancing the social interests of Malay with exclusive growth requirement and employing flexible leasing option, promoting equitable housing policy and fostering transparent dialogue. It is essential for achieving sustainable inclusive real estate development in Malaysia.